Residential Appraisal Report Writing and Case Studies. Chapter 2, Reporting Basics and Options. Page 6, Assumptions. The definitions section of USPAP. Used to provide us with this definition. Assumption. That which is taken to be true. That definition was removed from the 2018 through 2019 edition of USPAP. The Appraisal Standards Board deleted the definition of assumption, as its use is not intended to differ from the general English meaning of the word. The board also adopted a revised definition of extraordinary assumption in an effort to clarify that term and its applicability. We will address that on the next page. Assumptions, sometimes called ordinary assumptions, are made in virtually every appraisal assignment. For instance, do you complete a title search on every property you appraise? You don't? So how do you know if the property title is good and marketable? You assume it is so. The same goes for hidden conditions of the soil. Do you dig down in the backyard to make sure the soil and subsoil are stable and free of contaminants? Of course not. You just assume this is the case. According to Standards Rule 2-1C, even ordinary assumptions need to be disclosed. For example, I assume property's title is good and marketable and will render no opinions about the quality of the title. I assume there are no hidden or unapparent conditions of the soil or subsoil that would render it more or less valuable. We will discuss assumptions in more detail later in this course. End of page. Page 7, Extraordinary Assumptions. The revised definition of extraordinary assumption builds upon the definition of assumption, but they are different things. Extraordinary assumption, an assignment-specific assumption as of the effective date, which, if found to be false, could alter the appraiser's opinions or conclusions. Comment: uncertain information might include physical, legal, or economic characteristics of the subject property or conditions external to the property, such as market conditions or trends, or the integrity of data used in the analysis. The first thing to acknowledge with regard to an extraordinary assumption is that it is something we do not know, but we take it to be true. Second, while an ordinary assumption may be made in virtually every appraisal assignment, an extraordinary assumption is directly related to a specific assignment. We acknowledge that if we find that the extraordinary assumption is actually not true, then our value opinion could be impacted or changed as the result. This is what makes it extraordinary, because it is directly relevant to our appraisal or value opinion. Therefore, SR 2-1C requires that all extraordinary assumptions be disclosed clearly and accurately so that the intended users know that the value opinion depends upon the extraordinary assumption being true. An extraordinary assumption might be used, for instance, if we were to appraise a house with a small crack in the foundation. An appraiser is not expected to render an opinion about the structural integrity of the dwelling and is generally not qualified to do so. Simply, we do not know if the dwelling is structurally sound, but by implementing an extraordinary assumption that the dwelling is structurally sound, we can value the property without knowing or paying someone else to investigate whether the dwelling is indeed structurally sound. If we have a reasonable basis for this assumption, and if its use is necessary to develop a credible opinion of value, then we may utilize it in the appraisal process. If there is no reasonable basis for the extraordinary assumption, then it cannot be used to develop a credible appraisal. USPAP requires that we disclose the extraordinary assumption in the appraisal report. This disclosure gives notice to the client and intended users that our knowledge of the property only goes so far, and other information has been relied on, which, if found to be false, could have an impact on our value opinion. If this degree of risk is not acceptable, the client might disclose the use of the extraordinary assumption. We are also required to state that its use may have affected the assignment results. Failure to disclose the extraordinary assumption would be a significant omission in the appraisal report because the intended users could be misled regarding the appraiser's reliance upon information that is, to some degree, uncertain. End of page. Page 8, hypothetical conditions. Now we will consider the hypothetical condition. Whereas we believe an extraordinary assumption to be true, a hypothetical condition is something that we know is not true. Yet we appraise the property as though it were true. The difference between an extraordinary assumption and a hypothetical condition is the level of certainty that the appraiser has about the issue addressed at the time of the appraisal report. If the appraiser does not know for certain, but must assume one of the available choices to complete the appraisal, the extraordinary assumption is used because the level of certainty is less than absolute. However, if the appraiser knows something to be false and used the opposite in the appraisal, or knows it to be true and uses the opposite, the level of certainty by the appraiser is absolute. Therefore, the hypothetical condition would be used. In other words, a hypothetical condition permits the appraiser to tell a lie in the appraisal, but the disclosure of the hypothetical condition, tell a lie in the appraisal, but the disclosure of the hypothetical condition in the report informs the client that it is not currently true. Thus, the client is not misled. Hypothetical condition. A condition directly related to a specific assignment, which is contrary to what is known by the appraiser to exist on the effective date of the assignment. Results, but is used for the purpose of analysis. Comment. Hypothetical conditions are contrary to known facts about physical, legal, or economic characteristics of the subject property, or about conditions external to the property, such as market conditions or trends, or about the integrity of data used in an analysis. A good example of utilizing a hypothetical condition in the appraisal process is the appraisal of a property with proposed environments. When the appraisal uses a current effective date, whenever we appraise a home that is not yet built, for instance, we know with full certainty that the improvements simply do not exist as of the effective date of the appraisal, and yet the appraised value of the property reflects the completed improvements. Typically and correctly, the appraiser will disclose that the appraised value is subject to completion per plans and specifications. This is good, but not good enough. Additional language is required to clearly disclose the hypothetical condition and state that its use might have affected the assignment results. For example, we might state in a report, the appraised value is subject to completion of the improvements per plans and specifications based upon the hypothetical condition that the improvements were complete as of the effective date. The use of this hypothetical condition might have affected the assignment results. In this example, the USPAP requirement for a clear disclosure of the hypothetical condition is met. USPAP requires that a hypothetical condition be clearly and accurately disclosed, but does not specifically require that a hypothetical condition be labeled as a hypothetical condition. You are not required to use the exact words hypothetical condition in your report, although many appraisers believe that such labeling is a best practice. When the Fannie Mae 1004 form was revised in 2005, the following language was added on page 2 of the form. In the section which indicates the conditions of the appraisal as is or subject to completion per plans and specifications based on the hypothetical condition that the improvements have been completed. Emphasis added. End of page. Page 9, disclosing assumptions and hypothetical conditions. Standards Rule 2-1 of USPAP states that disclosure of assumptions, extraordinary assumptions, and hypothetical conditions must be clear and accurate. For extraordinary assumptions and hypothetical conditions, Standards Rule 2-2 states their disclosure must also be clear and conspicuous. This additional requirement for disclosure of extraordinary assumptions and hypothetical conditions is further testament to the fact that if an extraordinary assumption or hypothetical condition is not conspicuously disclosed, the appraisal report could be significantly misleading to the client and intended users. Conspicuous means that the disclosure must be apparent to an intended user reading the report. For example, if an appraiser uses a hypothetical condition that a contaminated property is free of contamination, and then buries the disclosure of the hypothetical condition in the fine print at the bottom of page 25 of the report, this disclosure would not be considered conspicuous, and it would probably result in a misleading report. As a reminder, it is not sufficient for the report to merely disclose the use of an extraordinary assumption or hypothetical condition. USPAP requires the report to also state that the use of the extraordinary assumption or hypothetical condition might have affected the assignment results. A brief quiz is up next. End of page. Page 10, check your understanding. This quiz has a total of 3 questions. There will be 1 question per page. You must achieve 66% to pass this quiz. Start quiz. Number 1, an appraiser's assumption that the subject property has no hidden or unapparent conditions of the soil or subsoil is an example of A, environmental site assessment, B, assumption, C, extraordinary condition, or D, hypothetical condition. I'm going to go B, assumption. Number 2, Kate notes an underground storage tank on a property she is appraising. The property owner gives her a copy of an environmental expert's report stating that the tank had leaked diesel fuel into the ground and there was significant contamination which was never remediated. In appraising this property, can Kate employ an extraordinary assumption that the property is free of contamination? A, yes. B, no. C, only if the client provides permission. Or D, USPAP does not specify an answer. I'm going to go yes. Number 3, under USPAP, disclosure of extraordinary assumptions and hypothetical conditions must be clear and conspicuous. True or false? I'm going to go true. Assessment completed. Finish. You passed. You got a 66.7%. You needed 66% to pass. So remember, number 1, an appraiser's assumption that the subject property has no hidden or unapparent conditions of the soil or subsoil is an example of, you said, assumption, and that was correct. Number 2, Kate notes an underground storage tank on a property she is appraising. The property owner gives her a copy of an environmental expert's report stating that the tank had leaked diesel fuel into the ground and there was significant contamination which was never remediated. In appraising this property, can Kate employ an extraordinary assumption that the property is free of contamination? You said yes, that's incorrect. The correct answer was no. If we have a responsible basis for an extraordinary assumption, we may utilize it in the appraisal process. In this case, Kate does not have a basis for this assumption because she knows it is false. Chapter 2, Extraordinary Assumptions. And number 3, under USPAP, disclosure of extraordinary assumptions and hypothetical conditions must be clear and conspicuous. True or false? You said true, and that was correct. End of page.